And to just get us started, can you please type in the chat your name, organization, what's your favorite summer treat to have on a hot day? And I'm gonna We're just going to let a couple more folks trickle in before I introduce our presenters today. And while we do that, please type in the chat your name, organization, and what's your favorite summer treat to have on a hot day. And I see that some of you are putting things in the chat. Thank you so much for introducing yourselves. And now I'm going to put up the slides and introduce our presenters for today. Just give me a second. So again, thank you for joining us for the Navigating Mainstream Benefits training series. Today is day 1 of 2 of our trainings on SSI and SSDI. And we're constantly, right now we're working with Charla Tran and Rachel Mina from the Law Foundation of Silicon Valley, who will be your 2 presenters today. And like I said earlier, I'm Sadaka Islam, and I'm from Homebase, which is a technical assistance nonprofit provider. We work closely with Santa Clara County's Office of Supportive Housing. One of the many things we do in the scope is bring you trainings on behalf of OSH, including this Navigating Mainstream Benefits series. And to pass it along, I'll give it to Charla and Rachel to introduce themselves and the Law Foundation of Silicon Valley.
I can introduce myself first, and then I'll let Charlotte introduce herself second, because she's going to be taking the first half of today's presentation. My name is Rachel Nino. I am the supervising attorney with the health program at the Law Foundation of Silicon Valley. I've been with our team for about 10 years and in the supervising position for about a year. Thanks for being here. I'll hand it over to Charlotte.
Hi, everyone. My name is Clara Tran, and I'm on the health team. I'm a staff attorney on the health team, and I've been with the team for almost a couple years now. Okay. And so, yeah, now we can just go ahead and I'll go ahead and start with the first half of the presentation here. So just a little bit about the Law Foundation of Silicon Valley. We provide free legal services in 3 subject areas: in health, housing, and children and youth. Rachel and I are from the health practice, and so we focus mainly on providing legal services to people living with physical and mental health disabilities, mainly in patients' rights, public benefits. And in public benefits, we help with programs such as Medi-Cal, general assistance, Social Security, and then on occasion, we do help with federal student loan discharges and name and gender marker changes.
Next slide.
So here's the training roadmap for today. We'll start off with basic eligibility for the Social Security benefits. There's 2 programs, and there's major differences between the 2 programs. There's the SSI program and the SSDI program. Then we'll move on to talk about how disability is established for the programs, and also eligibility for immigrants. Then we'll go on to the application process and the appeal process. So what happens if a client is denied benefits? Um, so, and then finally, we'll end with continuing disability reviews.
Next slide. Yeah, thanks.
Okay. So before we really get into all of the complex rules and all that information, we just want to let everyone know that it's really frustrating and confusing and hard to understand. So you don't have to memorize all the information that we're sharing with you, but our goal here is to help you identify the issues that come up so that you can refer clients to us when they are in need of help. But yeah, if a client ever gets a notice from Social Security and they have questions and they have an issue with their payments, then we're here to help with that. Yeah, and Social Security, they're very backlogged. We've had issues with contacting them as well, so it's hard for everyone. So next slide. Okay. So we'll go through the basic eligibility for Social Security benefits. So the Social Security Administration, they're a federal agency that administers two different disability programs. We have Social Security Disability Insurance and Supplemental Security Income, so SSDI and SSI. Both programs require the same finding of disability, so the same criteria for disability. There are some differences. The SSDI program requires that one would have had to have a sufficient work history in order to be eligible, whereas the SSI program is a program for folks that have low income. So there's a income and asset property limit. Okay. So we'll start first with SSDI. So it's cash benefits to people who are disabled or blind and who are insured by having paid contribution through payroll taxes. The monthly benefit that a claimant can get depends on how much they've contributed through the payroll taxes. And so for the year 2024, the maximum monthly SSDI payment is $3,822. And this would change every year. The earned monthly, oops, sorry. So there's a possibility that a claimant could be eligible for both SSDI and SSI benefits, and it's in cases where the client is getting SSDI and the earned monthly benefit is less than the SSI amount, then SSI may be able to make up the difference. So eligibility for SSDI depends on how many quarters of earnings a claimant has had.
Sorry, can we go back to the slide? I think we're on a different shared screen now. Okay, thank you.
Okay. And then with Medicare, after 24 months, SSDI beneficiaries will automatically start receiving that coverage. Okay, can we go back one slide?
Sorry, my computer started to glitch, so my apologies. It is going in and out, so let me just regroup. My apologies, you.
Sure, I can share if it's helpful. Do you want me to do that?
Yeah, either or. I just started to glitch. I think that's why I went in and out of slides.
Yeah.
Um,
Let me know if you want me to share my slides. I'm happy to do that.
Okay.
Okay.
And I think we just need one slide ahead. We need one go. Yeah, there we go. Okay, so then for the supplemental security income in the SSI program, it's also a cash assistance program, but it's for people who are age blind or disabled and have limited income and resources. So the amount of the benefits also differs based on a variety of factors. Typically, those that are blind are eligible for a slightly higher amount of SSI benefits. SSI is seen as a safety net program. So to be financially eligible, an individual must not have monthly income from other sources of more than the maximum SSI amount, and must not have resources exceeding $2,000, and that's $3,000 for couples. And once a claimant is eligible for SSI, they're automatically also eligible for Medi-Cal with no share of costs. Okay, so here is a chart just showing different categories for the SSI program. So the most that, and so if you see the top row there, independent living status, if someone is not living in someone else's household, their age, you can see it's $1,182.94 for 2024. And as I mentioned earlier, with blind individuals, the amount is a little bit higher at $1,267.32. Okay, next slide. Okay, so now we'll talk a little bit about Social Security's definition of disability. And so they look at a few things. The first is if the individual has an inability to do any substantial gainful activity, or SGA. So that SGA amount is the work earnings amount. In 2024, it's 1,550, and it'll adjust upwards every year. And so for those that are blind, the work earnings, the SGA amount is set at a higher amount at 2,590 a month. Okay. The second thing Social Security would look at is whether the individual has a medically determinable physical or mental impairment. And then if that's the case, then if that impairment can be expected to last for a continuous period of 12 months or more, or even result in death. Thank you. Next slide. Okay, so Social Security has a 5-step disability evaluation process. So if at some point in this process, we can answer yes, then the claimant would be found to be not disabled. So with the first thing is we would ask if the claimant is engaged in substantial gainful activity. So if they're working and they make more than that amount. If yes, then they would not be found to be disabled. If no, then we can proceed on to step 2. Step 2 is if the claimant has a severe impairment. And then if yes, we're going to look at does the impairment meet or equal a listed impairment. So Social Security has a list of impairments where at step 3, if there's enough medical records to show that the claimant meets that listed impairment, then they would automatically be found to be disabled, and you wouldn't need to move on to step 4 or 5. And so, you know, the hope is to meet one of the listed impairments, and that would be an easy way to qualify for benefits. And then the process would just stop. But if they don't meet one of the listed impairments, then we will still proceed on to step 4 to see if the claimant can return to his or her past relevant work. If they're not able to, then finally we look at if there's any type of work at all, not just, similar work or past relevant work, but just any type of work at all that exists in significant numbers in the national economy that the claimant can perform. And then finally, if the answer is no, then the claimant would be found to be disabled. Okay, so as I mentioned earlier, Social Security, they provide examples of conditions that are presumed to be disabling, so that at the step 3, DDS compares an individual's diagnosis, symptoms, and clinical findings, and functional limitations to the criterias of the listing. And if the medical records can show that the claimant's condition meets or equals the listing, then the patient is found to be disabled. And the listings are organized into 14 different systems. And then I think, as Rachel shared there's you can look at all the different categories and the listings on the Social Security website. For step 4 and step 5, so this is when the claimant does not meet one of the listings in step 3. We'll move on to step 4 and 5. We'll look at residual functional capacity. What this means is it's the most that a person can do despite all of their physical and mental limitations. We'll look at both exertional limitations and non-exertional limitations. So examples of exertional limitations would be at what level: sedentary, light, medium, heavy, based on how much a person can lift or carry. We'll look at ability to stand, walk, sit for certain amounts of time. Non-exertional limitations, so concentration, persistence, and pace, and a claimant's ability to interact with their peers and their supervisors and the general public. And then step 5, whether or not there's any job that the claimant can perform in the national economy. So we wouldn't be looking at the person's past relevant work, we wouldn't be looking at their dream job, but rather if there's any job at all where they can earn at least the SGA amount, the $1,550 a month or more. And if blind, the $2,590 a month or more. Next slide. So we just wanted to touch on substance use and what happens in the applications for Social Security benefits. So clients do not need to be clean and sober to qualify for Social Security benefits. But if a client does have an alcohol or substance use disorder, they must show that their impairments would still meet disability criteria, even once they're totally sober, even with total sobriety from the alcohol or substances. So they must show that those impairments would exist, whether or not they're reliant on the alcohol or substances. And so we would look at if the problems continue to occur when the client is sober, or only when, or if the problems are only there when the client is using. We would document the functional impairments that predate substance use, or ones that exist when the client is sober. And we'd look for organic impairments, traumatic brain injuries, neurocognitive disorders, trauma, access to disorders, personality disorders. Next slide. Okay, and then just for immigrants, whether or not immigrants would be eligible for the Social Security programs. So immigrants to the US are eligible for the for the SSDI program if they have worked and paid into the Social Security system prior to the onset of their disability. And so if workers have the sufficient work orders, that they would be eligible. For an immigrant to qualify for SSDI, they must be lawfully present in the US. And to be lawfully present, they must have a valid social security number. They must have been inspected by the Department of Homeland Security, and they must not have violated the terms of admission to the United States. Next slide. For the Social Security income is not available for non-citizens. However, DHS has granted eligibility in a very limited number of categories. And
Oh, looks like Charlotte froze for a second. Am I frozen for people? Charlotte might have frozen.
No, she's frozen.
Okay. Maybe we'll wait 10 seconds, and if she doesn't come back, I can pick up here. Charlotte, maybe, I know she's.
Or if Charlotte, if you can hear us, maybe turn off your video. That can sometimes help with connection issues.
Oh, there we go. You're back, Charlotte. Sorry, we lost you for a second. Oh, no, these are good. Okay, how about this? I'll start talking and talking about eligibility for immigrants while we wait. Charlotte, are you back on? Oh, you're back. You're just muted.
I'm
Okay.
so sorry.
No, that's okay.
Where did when did I freeze?
I would just say you were just starting to say that Department of Homeland Security has granted SSL eligibility for certain immigrants only, and that's where we kind of stopped off.
Yeah, and also that from what we've seen, most people don't meet these categories. It's not often that we have someone that meets these categories. Okay, thank you. And next slide. Okay, so individuals who do not qualify for SSI based on their immigration status, but who are disabled and low income should consider applying for the county program, the Cash Assistance Program for Immigrants, CAPI. Yeah, with the county social services. And then we have that information there. Next slide. Okay, so that brings us to our first poll question. There we go. So true or false, the Social Security Administration administers two types of disability programs and both require the same finding of disability. Here we go. So then, yeah, so that's true. Social Security does administer the two types of disability programs, SSI and SSDI, and they both have the same criteria for finding of disability. Oops. Righty. And number two, what are two of the disability programs administered by the Social Security Administration? So then it would be SSDI and SSI. SSI being the supplemental security income and the Social Security disability insurance. Okay, next slide. And then if there are any questions, we'll just pause for a minute here. And then Rachel will take
Yeah.
over and start with
Yeah.
the second half of our presentation.
Yeah, thank you so much, Charla. Yeah, we can pause here for questions. I have been monitoring the chat while Charlotte was giving her presentation. So I'm just responding to the second question here from Natalie. And I'll type it in. But for CAPI, no, residents do not need to have paid into SSA through employment, much like SSI. It's a needs-based program or a welfare program. So there's no requirement that you've paid into it the way, for example, Social Security disability insurance requires a pay-in. And so one helpful way I like to kind of think of is that SSDI, which is Social Security disability insurance, really is insurance. So to be eligible for it, you've had to pay your premiums or pay in through your payroll taxes, as Charlotte mentioned earlier. SSI and then the state equivalent of SSI, which is CAPI, are needs-based or welfare programs. So there's no requirement that you've paid in or purchased or made premium payments to make sure you get that benefit when you need it. Instead, it's just there for people who have no other basis on which to provide for themselves and they're too disabled to work. So SSI, is that needs-based disability benefit program. And then California said, well, SSI is this federal program and they exclude non-citizens. And so we're going to institute this program called CAPI, Cash Aid Program for Immigrants, which is going to allow lawful permanent residents, albeit not citizens, to apply for and receive these welfare benefits and for they're too disabled to work without any proof of payment into the system or through employment. And yes, Natalie, your follow-up question, she's asking, do they need a denial letter from SSA to apply for CAPI? Yes, that you do. A person who is a non-citizen needs to get a letter from Social Security saying that that person has applied for Social Security and has been denied due to their immigration status. And then they need to take that letter from Social Security into social services with them within a 6-month period of time to apply for CAPI. If you have that letter from SSA saying you're not eligible because of your citizenship status or your immigration status, and it's been more than 6 months, you have to go back in and get a new one. Those CAPI affect status change. Do you mean does CAPI? Yeah, okay, so this is actually a great question. I know we're kind of delving into a totally separate topic, which is public charge. And I know a lot of people were very concerned about the receipt of benefits and how it may or may not impact a person who is seeking to change their status from LPR, lawful permanent resident, also kind of known as green card holder in a more colloquial term, to citizenship. And the public charge rule in its totality does not apply to people who are going from LPR or green card holder to citizenship. The only time the public charge test comes into question is when a person is seeking admission into the United States or they're already in the US and they're seeking to be here permanently, legally as an LPR. So public charge is a test that is applied only to people who are trying to become lawful permanent residents. If a person is already a lawful permanent resident and is seeking citizenship, the public charge test does not apply. Now, for those who are seeking admission into the U.S. or who are in the U.S. and seeking to legalize their existence in the U.S. And are not yet LPRs or green card holders, the public charge test does apply, but those people aren't going to be eligible for CAPI anyway. So they're not going to be able to receive CAPI. So yes, there will be a public charge test, which is a whole lot of factors, only one of which is have you received public benefits. And so we usually tell immigrants who are concerned about public charge test, hey, DHS is going to look at a lot of issues to determine whether or not they'll grant you LPR status. Receipt of benefits is only one of those issues, and it's not the best idea to forego benefits you need for your well-being and health just because you think that might be a disabling factor in becoming an LPR. And also, a lot of the benefits that count against you in the public charge consideration or context aren't even eligible to the people to whom the public charge rule applies. I could give a whole hour and a half presentation on public charge in and of itself. It's changed a lot. It was very, very, very bad under Trump. It's better under Biden. And anyway, I could go on for that and do a whole nother presentation, but suffice it to say, hopefully that answers some of the questions that people were posing in the chat. Are there any other resources for immigrants to get income if they have a past record but are still disabled? I think past record, are you referring to like a criminal record? I'm not sure if you're referring to a criminal record, but yeah. So criminal records shouldn't, if you're disabled and you have a criminal record, that should not make you ineligible for CAPI. And CAPI is the one benefit for non-citizen immigrants to get benefits if they're too disabled to work. I can pause for one more minute before we roll into the next set of slides. Okay. Okay, great. If there's more questions, pop them in the chat. We'll try to answer them as we go through the presentation, or if not, we'll pause at the next section. And I'll answer one last question. Natalie, how long is the process from applying to receiving CAPI? I can't, I wish I could give you a solid answer on that. I think it varies. Usually it takes them, a couple of weeks to get the application into their system and like just get it uploaded. And then they have to send it over to an agency that does medical reviews to determine if the person is disabled, much in the same way that Social Security would send over an SSDI or an SSI application to determine if a person is disabled. And that disability analysis or review could take a couple of months. If a person gets approved right after that, great. If not, there may be a denial that you have to appeal on. That could add more time onto it. So I don't have a concrete answer for you, but I can tell you that like SSI and SSDI application can take anywhere from like 5 or 6 months to 4 or 5 years, depending on how quickly you get approved and whether you need to appeal and how many times you need to appeal. Not a satisfying answer. I'm really sorry. Yeah, honestly, the answer could be, it varies quite a bit. Could you list the docs that someone would need to apply for CAPI? I don't know the names of the forms off the top of my head. I absolutely know you need that letter from Social Security that says you're not eligible for SSI because of your immigration status. And then there's a specific form, maybe Charlotte, if you have a minute to just go into the social services website and pull up the information about applying for CAPI. I think it's got the form listed on there, and that's the one form you would send in along with that letter. But we also recommend people go into the social services office and sit down, and a representative could help you fill out the CAPI application and turn it in. And I'm sorry, I just don't know the form number off the top of my head, but it is on the County of Santa Clara Social Services Agency website. Okay, maybe we should proceed with the presentation and then we can filter through more questions as they come up. Next slide. Okay, so thank you so much, Charlotte, for talking quite a bit about SSDI and SSI in general, who's eligible, what it takes to become enrolled in the program. And now we're going to tell you more about the logistics of applying for SSDI and SSI and the appeal process too. So next slide. So this is just a summary of the application process. And this is just the application process. We'll talk about appeals in a minute because unfortunately many people who apply are denied and then they need to go through subsequent steps. But let's say you're working with an individual who just says, I want to apply. And they think they want to apply for SSDI or SSI, or they don't know. What we typically recommend is that people apply for both programs because it is Social Security's job to make a determination about whether a person is eligible for SSDI or SSI. And again, the factor being, well, you're eligible for SSDI if you have those work credits that Charlotte referred to, and you're disabled, or maybe you don't have enough work credits, and then Social Security will say, well, you don't have work credits, but we'll still make a disability determination and also look at your financials to see if you are low income and low assets. And thank you, Charlotte, for SOC 814 as the CAPI form. So anyway, we would tell people apply for both, and Social Security will make a determination as to which two you're eligible for. And then also that's important because let's say you're eligible for SSDI because you have enough work credits, but your SSDI is not a lot of benefits because maybe you're a low wage earner, so maybe you're only getting $700 or $800 in SSDI. Well, if you've also processed an SSI application, Social Security can then go ahead and say, okay, you get SSDI in this amount, but because it's not at the maximum SSI level, we're going to make up the difference between your SSDI benefits and the maximum SSI benefits by giving you SSDI and SSI combined. So the first thing we tell clients who are interested in applying to do is to call the national number at 1-800-772-1213, or to go ahead and file a claim online. SSDI is really easy to file for online. SSI is not as easy, but you can at least go on and start or submit, a notice on SSA's website saying you want to file for SSI. And the important thing is that the day you call that number or go ahead and start that file claim online, you establish a protective filing date. That is the date where Social Security will keep in their records as the date on which you first applied for SSDI and SSI, so that if and when you are approved, your retroactive pay can be calculated in accordance with that protective filing date. So people are like, oh yeah, I'm gonna apply, but I'm not quite ready yet. I'll give it a couple weeks. It's like, no, go ahead and call. At least get your claim in there. Let Social Security know you want benefits so you can establish that protective filing date. Once you've started your application online or you've called the Social Security national number and they've set you up for an appointment with your local office and you've got your PFD, the next thing Social Security is going to ask you to do, either online if that's where you've started, or if you've asked for an in-person report or it's an SSI application, you need to go and finish it in person anyway, you're going to have to complete an application and a disability report. And there's quite a few forms that go along with this. The application is just about a general statement of I'm applying for, here's when my disability started. The disability report has more details about exactly what your disability consists of, how it impacts your ability to engage in activities of daily living, how it impacts your ability to work. They're going to ask for, do you use any kind of assisted devices? Or can you give me your medical records, please? Actually, sorry, not your medical records, but your medical contacts so we can obtain your medical records. And we tell clients to be as thorough as possible on these disability reports and to list any and all doctors they've seen in the last 2, 3, 4 years so that Social Security can pull sufficient records. And then to list the phone numbers and addresses of the places where you've received medical treatment. Sometimes Social Security will also send out what's known as a adult function report. And that's a report that's, thanks for sharing us your disability information. Now we want to know how you function on a day-to-day basis. Like, do you go out with friends? Do you go out to dinner? Are you able to take care of pets? Do you take care of family or friends? What do you do on a daily basis? Can you shower? Can you prepare meals? And they may send out a similar report called a third-party adult function report, where they ask somebody close to the claimant to share information as well about what that person thinks about the claimant and their ability to do things like activities of daily living. Once all of that application and report paperwork is into Social Security, Social Security will make a determination about the non-medical eligibility. So that's either for SSDI, does this person have enough work credits? Or for SSI, is this person low income and have limited assets? Once the person is past that, once Social Security has determined that the person does qualify for either or both SSDI and SSI, as Social Security will send all of the information it's gathered and send it to the DDS, the Department of Disability Determination Services, which is the state agency that Social Security contracts with. And that state agency assigns a disability analyst who reviews all the records and makes a determination about whether this individual meets Social Security's criteria for disabled. After DDS processes all of the paperwork and makes a determination, yes, disabled, no, not disabled, they will return all that information to the local Social Security office, who then sends a letter to the claimant. You've been approved, congratulations, or I'm sorry, we've decided you don't qualify. Here's your appeal rights. So that's the application process. That can take time. You can see it could take a month or two, maybe 3 or 4, maybe even 6 months by the time it gets to DDS and back to the claimant. Okay, so next slide. Next slide, please. Oh, thank you. So, perfect. So application process getting started, just a little bit more fleshed out information from the previous summary page. You can call the national hotline or file the claim online, and the website's linked there. People can also, if they want, and we don't recommend this because you may sit and wait and wait and wait, but claimants can also visit a local Social Security office in person and say they want to apply. But sometimes either you wait hours to get your number called, or you might go and say, the person might go and say, well, great, thanks for coming in to tell us that. You have a protective filing date, but we're not taking applications right now, so come back on this date and time. So we usually recommend that you start it online or call 1-800 number to get that appointment, so that when you do come in, Social Security will have an appointment set up for you, or they can do it via phone or in person, and then you will have a dedicated staff member ready to take that application for you. We do recommend applying online if you can, and print out confirmations of the submission, so that your client or you knows, yes, this went in, we have proof. So if Social Security says, "Boy, we can't find it in our system," you can say, "Here it is right here, and here's the date on my electronic copy." We do want people to know, and this is something we often do for the clients, but caseworkers can do this as well. If you're assisting a client with starting an SSI application, you can sign on as that person's authorized representative, or AR, which means Social Security will recognize that you are representing this claimant in this application process. And you know, people don't want to stay on the AR all the way through the hearing oftentimes, because going to a hearing usually requires a pretty nuanced understanding of the disability process and the legality of getting on benefits. But it can be helpful just to be on as the AR during the application process, because sometimes we have claimants who are unhoused or who are struggling with some pretty severe mental health impairments. And so if clients are having trouble getting mail or responding to mail, as the AR, you will also get all the mail from Social Security. So you can call the client up and say, "Hey, did you get this piece of mail? We need to respond to this." You just make sure you're keeping track of it and helping the client get through this process. So it's good, because as the AR, and as I noted here, you will receive copies of all correspondence that not only Social Security, but also the Disability Determination Services sends to the client. Next slide. So I talked a little bit about this at the very beginning in the application process summary, but the application process does include several questionnaires that applicants for benefits must fill out. We call them applicants for benefits or claimants. The disability report, where you're detailing the medical history and your current treatment. As I mentioned before, the person wants to give accurate information about all places where he, she, or they receive medical and mental health treatment, and include correct addresses and phone numbers. And that is so that DDS, when they're doing the review of the client's disability, has all the client contact information, all the client's medical information, so that person can request medical records and make a really thorough and hopefully the best possible decision. Because if any of that information is inaccurate, DDS will not get those records, and that could weigh against your client in receiving benefits, because they might say, "Well, I don't get information from regional hospital because I didn't know about it," or they provided me with information regional, but it wasn't accurate, so I can't get this person's medical records. So I'm going to make a decision without them, and maybe those medical records were really weighty and really helpful in proving that this person is disabled. So we want to make sure DDS can get all information possible, so we encourage claimants to be as thorough as possible in the disability report. Next slide. I mentioned the adult function report and the third-party function report as well, and that's just the forum through which the client and somebody who knows the client very well can speak to the client's activities of daily living, which we refer to as ADLs, and that client's general functioning. One big tip in this section is when a client is filling it out, sometimes clients are, they want to kind of paint a rosy picture, and so they might talk about, like, "Well, I'll get up and go for a walk, and I'll make myself some lunch." Like, no, clients, let's not focus on what happens on your best day. And everybody has best days. Everybody has good days where they can do more than they do on other days. But we want claimants who are disabled and who believe they're entitled to benefits to really focus on how difficult things for them on their harder days, because those are the days that truly emphasize why a client is too disabled to work and why a client should be eligible for benefits. And then the third-party function report, same thing, but from a third person who knows them client very well. And case managers can fill out this form. So it could be a friend, it could be a family member, it could be a case manager. And then Social Security will also want to know a person's work history report, which details the client's jobs for the last 15 years to see, so Social Security can see, here's what you've done before. Have you built up enough credits in the system? Are you able to do your past relevant work? Because that's part of the analysis. You may remember when Charlotte talked about the 5-step sequential evaluation process. Step 4 is asking whether or not the person can do their past relevant work. So Social Security is going to ask about what the client has been doing for the past 15 and now actually only 5 years, which makes it less onerous, which is really good for us and for clients. So make sure that clients fill out this work history report as well, with as much information as possible about their work history. Next slide. Okay, so let's say you've gone through that application process, got all those forms back into Social Security. Social Security shipped over your file or your claimant's file or your client's file to DDS, and DDS is reviewing it, and DDS is getting, you know, your medical records from all the different providers that you've identified as an applicant. DDS might say, well, yeah, this is good information, but I think I need a little more information about the client's medical status, physical or mental, and I'm not getting as much as I need from the records. I'm going to ask this person to go to a consultative exam, which is an exam paid for by DDS or Social Security to basically examine the patient to see if there's additional evidence that either can beef up the record or maybe there's conflicting evidence in the record and treating providers are saying, well, we see them doing this well. No, we don't see the person doing that well. They're really struggling with this, or they're not struggling with that. DDS might say, oh, well, evidence is conflicting, or maybe I just don't have enough. So I'm going to get another person to weigh in on this client's physical and or mental health impairment so I can have something more to go off of when deciding whether or not this person is disabled. So we call these CEs or consultative exams. CEs, the consultative examiners who handle these CEs are non-treating doctors, meaning this is not the person's normal doctor that they go to see for whatever they're, you know, handling, whether it's their primary care physician or cardiologist or psychiatrist. No, it's not anybody that treats the person routinely. It's a non-treating doctor who has a contract with DDS, and these consultative examiners provide a brief one-time exam. And we find these exams oftentimes to be really problematic because they cannot really reflect the true range of a client's impairments when you've met with a person one time for sometimes only 15 minutes, 30 minutes, maybe an hour if you're lucky. So we do find many ways in which we need to challenge these exams. If the DDS says, oh, look at this exam, actually they say the person's not disabled, we're going to deny them. We might go back and say, no. The CE exam is not a real true indicator of the person's disability. But even though we find these exams to be a little bit difficult and often not reflective of a client's true impairments, we do tell clients they need to go to the CEs. If they can't attend a CE, they need to call and get it rescheduled. And clients, and if you're the AR, will get a notice by mail telling you when and where the CE is. So we always tell clients to watch out for these and to go ahead and go to those appointments as scheduled or reschedule them if necessary. Okay, next slide. Okay, so we're going to pause for a brief poll. There's a quick question. How can a client start an application for SSDI and their SSI benefits? Should they call the National Social Security Office? Should they file a claim online? Should they visit a local Social Security office? Or all of the above? Okay, it looks like we have, oh, I'll give it, oh, I can see at the top. Okay, looks like there's 59 people on, so I'll give people another couple of seconds to answer. Okay, slowing down. So thank you to those who participated. I mean, really, all of the answers are correct, but the best answer would be all of the above because you can call the national office, you can file a claim online, you can visit your local Social Security office, which is probably the hardest way to do it, but you can also do all of the above. Great, thank you so much. I think I can hit share results and stop sharing. Okay, great. So next slide, please. Okay. Oh, I think this poll, I'm so sorry. Let's pause on this poll question. I don't think we've gone through this material and maybe my slides got juxtaposed slightly and I apologize, but maybe we can go to the next slide and I can come back to this. Okay. So we talked at length about the application process and thank you for listening in on that. It is not an easy, it's kind of an uphill battle to apply, but let's say you've got that application process in and DDS makes a decision, sends it back to Social Security. Social Security sends it to you as the AR or your client. That is called the initial decision. If it's favorable, great, awesome. Client's going to get on benefits, going to move ahead. Client's going to get their retro pay and their ongoing pay. And you can tune in next Thursday for issues related to post-eligibility, meaning issues that come up for people who are on benefits, but there's still stuff they have to deal with. But let's say the person gets a denial after that initial decision. They're not, it's not done and dusted, right? There's other steps this person can take. They can then file what's known as a request for reconsideration, or more colloquially, sometimes we'll refer to it as an appeal. After the reconsideration, if you get another unfavorable decision, you can ask for an administrative law judge hearing, and our office often represents people in these ALJ hearings. We also often represent people at the recon phase as well, but we'll go to the ALJ hearings and argue in person that the person meets the criteria for disability and should be approved for benefits. After the ALJ hearing, if you still get an unfavorable decision, the person has a right to file another appeal at the Appeals Council, and that is a paper-only appeal. So you just submit an argument about why you feel the ALJ made a decision in error. Errors in judgment, error in judgment or application of the law, and you ask the Appeals Council to either reverse the decision and approve the person for benefits, remand the decision for a new hearing, so you can go to ALJ again and have a new hearing, or unfortunately, sometimes the Appeals Council denies. If you get to the point where the Appeals Council has now denied and said, no, the ALJ hearing stands, that ALJ's decision stands, you can go up to the district court and ask the federal district court to review the matter as well. This can be a very lengthy process. It can also be made longer by the fact that sometimes, you'll go to ALJ hearing, get an unfavorable decision, go to Appeals Council remands for a new hearing. You have to wait for a new hearing, go to an ALJ hearing. They still issue an unfavorable decision. You bounce back up to Appeals Council. Appeals Council denies. You go to district court. So I mean that's kind of worst case, more like most dystopian kind of fact pattern. But that's why you do see people bouncing back and forth between ALJ and Appeals Council and district court, and it can take years to get on benefits. More often, though, we see once you get to the ALJ stage that there is an increase in approvals. And so, some cases do go up to Appeals Council and District Court, but we try our best to see if we can win a case at ALJ. And the rating for the success rate really goes up. Like initial decision success rate is really low. Recon is slightly higher. Administrative law judge, we see people maybe like 50–60% getting approved. And then Appeals Council, even a little bit more. So we tell people not to lose hope. We can continue to appeal. Sometimes they don't get approved ever, and that can be very difficult. But oftentimes, sometimes it just takes time going through the system to finally get somebody to understand that this person is disabled and entitled to benefits. Next slide. So it's important to remember that there are deadlines. So if a person's denied either after the initial application, or they denied on recon, or they're denied or given an unfavorable decision at hearing, if you want to go to the next level, which I walked through in the previous slide, you will get a notice from Social Security telling you that you've been denied and that you have a period of time in which you need to appeal the decision. And that appeal deadline is 65 days. It's 60 days, and then of course Social Security adds on 5 more days for mailing. So if you get a denial, you or your client gets a denial on July 1st of 2024, and you say, I'm going to appeal it, or I'm going to ask for an ALJ hearing, or I'm going to go to Appeals Council, whatever the next level in the process is, you would have from July 1st until September 6th, really, to get that application or that appeal in. So count from the date on the notice, 65 days out. Those are calendar days, not working days. 65 days out is when your appeal is due. We often encourage people to file online. It's really easy to do that, even easier than starting an application. You can just just Google Social Security appeal, and it'll take you to a page where it says click to appeal, and you can go ahead and do that. Sometimes clients want to go in and appeal in person at the office, and if they do, we ask clients to get a state stamped copy as proof, because appeals, just like applications, can get lost. What happens though if a client wants to appeal either an initial denial or a recon or an ALJ decision, and they've missed that 65-day deadline? Well, we often talk to clients about whether they have a good reason for missing the deadline, because just because you missed that 65-day deadline doesn't mean you're kind of DOA. It means that if you have a reasonable explanation for why you're late, we can write a good cause letter and explain to Social Security, yes, this is past the 65-day deadline, but the person had these reasons for being late. So please take their application anyway. And we help with a lot of these letters. So if you see a client with this situation, please feel free to refer them to us. I think some examples of good cause are maybe a person's unhoused and they don't get their mail as often. And so they missed a letter, or maybe they were having a personal crisis or a family emergency and they couldn't attend to this and had to take back seat to something going on in their personal life. Or maybe a person is really struggling with mental health impairments and they were, really symptomatic or going through a period of psychosis and they missed the deadline. Or they had some serious physical health impairments and they had to be hospitalized for a period of time. Those are all reasons why you may want to file a late appeal, and there's good cause for doing so. So don't get dissuaded if you miss the 65 days. Send them to us and we'll see what we can do. Next page. All right, let me pause for questions here because we just processed quite a bit on the application and appeals process.
Would you like me to go back to the poll 4 question?
Yes, thank you. Yeah, so let's take the quick poll question and then I can get to Natalie's question. So what is the appeal level immediately following recon? Do you go to appeals council? Do you go to an ALJ? Or do you go to district court? Actually, a few more seconds. I think we got like 67% participation last time, so I'll give another 30 seconds. 30. Okay, it looks like it's slowing down. So yes, the next step, as you may recall from the slide we walked through, the first step is initial application. The second step is reconsideration. So what follows recon? After the reconsideration, the person is entitled to go to an ALJ hearing, administrative law judge. Only after a law judge delivers an unfavorable hearing would you go up to appeals council. And then from appeals council, then you're done with the Social Security system and you're moving out to federal court. And that's when you would go to federal district court. Okay, so initial, recon, ALJ, appeals council, district court. Okay, Natalie, is it fair to assume that if they don't qualify for IHSS hours that they won't get SSDI, SSI? No, I don't think that's necessarily a fair assumption. I think that a person can be disabled and not able to work. And the analysis for that is different from whether or not somebody needs help to be able to remain independently in their own home. Now, can some of that overlap? Absolutely. But I think that there's two different analyses. So I wouldn't immediately assume that if somebody doesn't qualify that they won't get SSD or SSI. I think there's a lot of, it's hard for me to answer that question kind of like with total, total kind of, not sincerity, but like with 100% of an accurate answer, or accuracy is the word I'm looking for, without really knowing more about the person's situation. But there may be reasons they don't qualify for IHSS because IHSS is offering certain services and maybe the person doesn't qualify for those services, like they don't need paramedical care or they don't need help getting up and getting to the bathroom or showering. But maybe they have some pretty severe mental health impairments that means that like they're on medication and they're sedated heavily because of psychosis, and then they can't get up in the morning and get to work, but they could still wake up later and bathe themselves and cook themselves lunch. So again, there could be overlap, but I wouldn't necessarily say that if you don't get IHSS, you're not going to get SSDI or SSI. I think there can be periods or circumstances in which a person could qualify for one and not the other. Any additional questions at this time? Okay. Okay, I think we can push ahead to the slides. The next slide. Okay. So we are starting to get into some of the post-eligibility issues, which is also going to be a main focal point of our presentation next Thursday. Post-eligibility issues refer to eligibility issues that arise after a person has become eligible for benefits. So now your client is on SSI or SSDI or both. that doesn't mean it's smooth sailing ahead. There can be still a lot of things that you have to deal with when you are receiving disability benefits from Social Security, that a person needs to be aware of to make sure they, can make it as kind of seamless and easy as possible to continue receiving those benefits without, dealing with additional hiccups or problems in the future. One thing people cannot avoid, though, is once you're on benefits, SSDI and or SSI, Social Security is entitled to and required to do what are known as continuing disability reviews. I think the name is fairly self-explanatory. It just means that if somebody's on benefits, Social Security is from time to time going to continue to review that person's eligibility for benefits. So your client gets on SSDI, well, maybe 3 or 4 or 5 years later, Social Security says, let's take a look at your case. I'm going to look at your medical records and see if you still qualify for these benefits. And if you do, great, you're going to keep getting them. If you don't, we're going to terminate them. Because maybe they say your disability might not last 10, 20, 30, 40 years the rest of your life. We need to make sure you're still getting benefits to which you're entitled. And if you're not entitled, we're going to stop them. So Social Security conducts CDRs on a semi-routine basis. Sometimes they get overwhelmed or swamped and they don't conduct them as frequently, but their standard procedure is to conduct them every 3 to 5 years for individuals. So let's talk about CDRs in a little more detail. Next slide. Okay, so Social Security may conduct CDRs, and they often conduct them approximately every 3 years. And that means every 3 years for any given individual. So if an individual's qualifies for benefits in 2024, Social Security may look at their eligibility again in 2027, and then in 2030, and then 2033, and so on and so forth. That being said, that's their goal. Social Security doesn't always achieve that because sometimes they're backlogged. Additionally, sometimes Social Security will review and do a CDR for a person more frequently than every 3 years if the person's disability is one that Social Security expects to improve quicker. And sometimes an ALJ will even say in his, her, or their decision, I am awarding this person benefits. However, based on what they've testified to and what their medical records show, I think this disability is only going to last 18 months. I recommend that Social Security does a CDR in 18 months. So a CDR may actually be more frequent than the 3 years. But what we tell people who are on benefits to do is just absolutely keep Social Security informed about your address at all times. If you move, whatever, out of the city, out of the state, just from one address to another, make sure Social Security knows what your address is. Because once you're on benefits, it's, like I said, not just smooth sailing from there on out. Social Security will still contact you about issues like we're doing a CDR. And Social Security is going to send a client a letter by mail saying, we're reviewing your disability benefits, more to come. And that person needs to be aware that their benefits are being reviewed and they need to be ready to comply with any requests or questions or concerns from Social Security to ensure that they're not terminated from their benefits. And then once Social Security starts the CDR, Social Security will often ask the person to fill out all new questionnaires, very much like the questionnaires they filled out when they first applied, like the disability report, the adult function report. Perhaps they send a third-party function report to a friend, and Social Security is going to say, fill this all out and send it back in. We're going to start an analysis. And then Social Security does the same thing. They collect medical records, they collect the applications and the forms filled out by the client and the client's close family friend or case manager, and they send it off to DDS, who does an analysis, and that DDS person will say, yeah, they're still they're still disabled, benefits should continue, and then that person will get a letter saying, good, CDR is over, you will continue to receive benefits. Or if the opposite is true, Social Security and DDS determine that the person's disability has improved and they now can go back to work, the person will get a letter saying, we reviewed your benefits and your disability, and we find that you are no longer disabled according to our law. You are now being terminated from benefits. If somebody goes through the CDR process and receives a letter of termination of benefits, that person does have the right to appeal, just like a person would appeal if they applied initially and were denied. They can go through the same appeal process. So first step is that request for reconsideration. If that's denied, the next step is the ALJ hearing. If that's denied, appeals counsel. And if denied again, you can go up to federal district court. So same levels of appeal and due process to ensure that the person's not just cut off of their benefits without any kind of, as I mentioned, due process to really fully evaluate whether they're entitled to ongoing benefits or not. Next slide. So as I mentioned, if a client's disability has ended, they're going to get what's known as a notice of disability cessation. What I really want to stress with the notice of disability cessation is that while you do have 65 days to appeal it, and we talked about those 65-day appeal deadlines a little earlier, if the person wants to continue receiving their benefits while you appeal, they need to appeal much sooner. They have to appeal within 15 days. In other words, 10 days for appeal plus 5 days for mailing, so that not only can they continue their appeal and make sure they get more due process, but they still get their benefits while they're appealing. So the deadline for appealing and continuing to receive benefits while the appeal is pending is 15 days. We do everything possible to help clients submit that appeal within 15 days, because otherwise you can argue good cause, but there's typically a lapse in benefits, and then you have to work with Social Security to be like, yeah, we didn't file within 15 days, it's late, but here's the good cause. Get their appeal in and also reinstate their benefits retroactively. And we can do that. It just takes more time, and the person may have a lapse in benefits, as I mentioned, and that's hard for people. So you can help them file this appeal online as well. Try to do it within 15 days so they can get their aid paid pending or their continued benefits. And if you can't make that 15-day deadline, we definitely recommend that you send this client over to our office so we can help with filing that late appeal and helping try to get aid paid pending in between. Okay, next slide. All right, I'll pause here for questions as well. Yeah, okay. A question from Deepthi. Would you be able to address what the most common reasons for denial of benefits are, and what aspect of the application will be most important to focus on? So let me take one question at a time. So common reasons for denial. So for SSDI and SSI, off the bat, when Social Security does that first review before they even send it off to DDS, they're just trying to determine whether the individual has enough work credits or is low income and has limited assets. So if Social Security says this person doesn't even have enough work credits for SSDI, that may be a basis for denial. Or if Social Security looks at the person and says, well, okay, they don't have enough work credits, maybe they're SSI eligible, but no, actually we see they have earned income. They have money in their bank account. They have, assets as well. They're not going to qualify because of their income asset level. That could be a basis for denial. But if a person passes that kind of initial threshold of non-medical eligibility, and then it's sent over to DDS, I mean, typically what we see the reasons for denial is it's just a generic, and unfortunately it's not very helpful, but Social Security says, we have reviewed your medical records and we have found that you are not too disabled to work. We think you can work. And so that's really the main reason for denial of benefits. And it's hard to come up with like the most common reasons, because every time Social Security says you're not disabled, we're denying you, it's very case specific or fact specific, because each person is going to Social Security and saying, here are my symptoms, here are my physical impairments, here are my mental health impairments. Somebody else has totally different impairments. And so there's no one common reason like, oh, congestive heart failure, that's not sufficient. No, it's more just like, we have looked at your medical records and we found that you're not too disabled to work. You can work and earn more than $1,550 a month, so we're not going to approve you for benefits. And with that being said, what aspect of the application would be most important to focus on? I really think that disability report is so crucial, because that is the way that Social Security and the DDS analysts get all the information possible about the treatment a person's been receiving and where their medical records live, so that DDS can get all the medical records, not just a little bit of them, not just a segment, all of them. If the client says, I have mental health and physical health impairments, you got to bring all of that up. Don't just throw down one or two things. List every single disabling factor, and anybody who's ever treated the person for the disabling factors within the relevant time period. So for SSDI, like maybe the person says, I've been disabled since 2022 because of a car accident and TB, traumatic brain injury. Get all the records back to 2022. Don't leave anything out, because we just want DDS to have as much positive and helpful medical information as possible in order for them to really get the best picture of this person's impairments and then hopefully not turn around and deny them. I think this question, and I'm not sure this question is being asked again, but for CAPI, do permanent residents need to have paid into SSA through employment? Maybe that's a repeat question before, but yeah, no, the answer is no. You don't have to pay into SSA through employment for CAPI. CAPI is not an insurance-based program. It's a needs-based program or welfare-based program, so you don't need to have paid in for it. It's just eligible and available for people who are eligible for it. Okay. All right, next slide. It might be. Okay. So we put this slide together for this presentation because in past years we've had people say, oh, you know, here's some questions that we would like answered, or it's a list of from us about what questions we often see. And so we wanted to make sure we just address some of these questions in case, you know, you think of these questions later and go, I wish I had asked that, or maybe you hadn't thought about this, but having to hear it written down, it's like, oh, good, I'm glad we mentioned that. So the first question I think we talked about a little bit at the beginning is, should the client apply for SSI, SSDI, or both? We often get asked that question and our answer is always both. Both. There's no harm, and that allows Social Security the ability to determine if they're eligible for SSDI for work credits, or if they're not eligible for SSDI, then take a look at their income and asset level to see if they're eligible for SSI. So both. Please help your client apply for both. Should we screen applicants for initial eligibility given the length and complexity of the application process? We often would say no, because screening applicants for initial eligibility is a little bit of a kind of a subjective analysis. And if you are, if you're not a lawyer and you don't know Social Security's processes in and out, then I would always tell people, go ahead and apply. Yes, the application process is long, it can be onerous, but if a person wants to apply, I think we give them the tools to do so, and let Social Security do the screening for eligibility first, and not, try to kind of deter anybody from applying, because you never know when somebody might be eligible. There may be factors we don't know about. So we don't encourage people to screen. We just say if somebody's interested in applying, tell them how to apply, get that process going, and then just give them an honest understanding of how long it could take, so that they know what they're getting into. How do I know when a client's disability began? So I think you ask, one clue is obviously like, I stopped working on this date because, I had a major accident, or I was in a car accident, or, I started having really severe mental health impairment symptoms, or I was hospitalized, and that was the first time I couldn't go back to work. So one kind of giveaway is, well, this is the date I stopped working, and it was because of my disabling condition. I also think that, if you don't know for sure when a client's disability began, I think you just tell Social Security a rough estimate based on what the client thinks. So even if it's like 5 or 7 years back, maybe the benefits aren't going to go back that far in the end, but it's no harm to say, well, he or she or they first started having symptoms this far back, right? So try to talk to the client about, like, even if you were still working a little bit and your work hadn't stopped, when did you start having these symptoms? When's the first time you started feeling like you were dealing with some auditory hallucinations or visual hallucinations? Or when did you start having heart palpitations? When did you go in to see the doctor for the first time about your concerns, or your cardiologist because you were having problems with your heart? Anything like that to help you kind of set a framework for around when you think the disability may have began. How far back should I request medical records? I think that's a really good question too. We talked about that a little bit earlier. And essentially, for SSI, we usually say you should request medical records for up to 2 years prior to the application. So if somebody is, applying for SSI and they say, I'm applying in July of 2024, when they fill out that disability function report, you're going to put 2 years of medical records prior to that. So maybe you want to list the client's medical records from July 2022 onward. For SSDI, I think medical records should be indicated as far back as when that first person indicated they first became disabled. And again, whether it's when they first started having symptoms and seeing a doctor, or when their work stopped because of their disability benefits, that's how far back I would request medical records in an SSDI matter. How will a client know if their SSDI or SSI application has been approved? We always tell clients, keep your mailing address up to date with Social Security at all times, because Social Security will send you a letter. So it's really important to keep your eye on the mail after you've applied. Yeah, and how should we navigate large amounts of back pay if a client wins on an appeal or after a hearing? That's a great question that we like to highlight for people, because you may wait 2 or 3 years to get on SSI or SSDI. You may have $30,000, $40,000, $50,000 of money coming to you. For SSDI, a large back pay is okay because it's a program that's insurance-based, and so Social Security doesn't care how much you have in your bank account or what your assets are. And so, you know, a person can choose to spend the money, keep it in savings, do what they want with it. SSI is a little trickier. If a client has a large amount of back pay from an SSI hearing, because SSI is a welfare-based program, and they are looking at how much income and assets a person has, the first thing Social Security does is say, okay, you're on SSI now, and we owe you $20,000 of back pay, hypothetically. We're going to pay you those $20,000 in 3 installments, and those installments are going to be 6 months apart. So yes, you're going to be getting your month-to-month pay every month, and here's your first lump sum of your back pay. And in 6 months, you're going to get a second lump sum. And 6 months later, you're going to get a third lump sum. And then Social Security tells the person, once you get that lump sum, you have 9 months to spend it down before you potentially risk making yourself ineligible for benefits because you have too much in your bank account. And so then we often talk to clients about, okay, now you have this lump sum in your bank account, you got to spend it down within 9 months. How are you going to spend it down? Make sure you're spending it down on yourself. You're not donating it. You're not gifting it or giving it away. You're buying food for yourself, furniture for yourself, taking care of medical treatment for yourself, taking a trip for yourself, whatever it may be, just so you can spend it down. And then we also advise clients to keep receipts and proof of what they've spent it down on in case Social Security wants to know, because Social Security is trying to avoid a situation in when a person kind of pulls all the money out of the bank account and sticks it in the pillow for savings for later on. So they may be particular and say, okay, you know, we saw that 9,000, you know, that lump sum payment go back into your bank account and then a big chunk of money come out. Where is that money? What did you spend it down on? We want to see. We don't want you to have just, you know, shoved it in a safe at home or sticking in your pillow. We want you to spend it on your own needs, because this is a needs-based program. And we want that money to be spent down to make sure you're continuing to be on SSI and be eligible for SSI. Okay, next slide. We're getting towards the end. Okay, I'll pause really quickly before I go through conclusions and just answer the 2 questions in the chat. Okay, so there's one question that says, I have a client who tried to apply for regular Social Security. I presume you mean retirement. She's 62, and because she hasn't been able to work, the website directed her to SSDI. Is it possible for her to get both SSDI and SSA? She needs income ASAP. So if she's 62, I'm going to guess that she's at like the age of early retirement. Yeah, in which case I'm a little confused. Those facts don't totally line up, because if a person is on SSDI or eligible for SSDI, as soon as they hit early retirement age, they are transitioned immediately to Social Security retirement. There's no way for a person on SSDI to say, I'm going to wait till full retirement age. They get an automatically transition to SSDI. If your client tried to apply online and then she got directed to SSDI, I would think it's worth a phone call to the national office to try to get her an appointment, and then get her in person or on the phone to talk to her representative about her eligibility. My other concern is that if she hasn't been able to work ever, it is the case that she's never worked or she hasn't worked in a long time. She hasn't worked for 5 years. Okay, but she does have work earnings from at some point previous. Okay. Oh, okay. Yeah, I'm totally okay. Sorry, I'm thinking this through. She hasn't worked for 5 years due to a medical condition, and she didn't apply for SSDI in the past, did she? She's never applied for SSDI part. No, because she thought she'd get better. Okay. I'm not quite sure what's going on, because if she's 62 years old and she tried to apply for SSDI, I would think Social Security would go, yeah, no, you're 62 now. Like, it's time for you to get on early retirement. I would try giving Social Security National, the 1-800-772-1213 number, a call and ask for her to get an appointment with somebody in person. I don't know what the system is pushing her through to do. That doesn't sound right to me, because again, as soon as a person's on age 62, if they can't work, they're not going to get SSDI, they'll get early retirement. And if they've already been on SSDI, Social Security automatically puts them on early retirement because they want people off of the SSDI program. So I would reach out and make a phone call. If you have further questions and this client's still having trouble, we're going to talk about ways to refer people to our office, and you can do that. Is the back pay taxed prior to release of funds? No, but funds still have to be reported when you do your taxes at the end of the year. Now, if a person's getting SSI, they might not have a whole lot. So they might not even owe taxes on it at all. Or maybe they do have quite a bit and they do still owe some taxes, but it is not taxed prior to the release of funds. The full amount is released. And then when the person has to do their taxes for that year, so like let's say they have big back pay in 2024, when they do their taxes in 2025, they will need to report it at that time. Okay, and then I see a question. If a client applied in the past and was denied, is there a limit on times the person can apply? I'm gonna have a follow-up question before I can answer that. Rebecca, did this person apply, get denied, and drop the matter, or did they go through the appeal process and all the way to an ALJ hearing? Because my answer is, like most attorneys, it depends. And maybe I can break that down a little further even. So if a person has applied and gets denied, and then they don't do anything else, they don't go through the rest of that kind of due process system, like the appeal and the ALJ hearing, yeah, you can keep on applying. There's no limit to the times you can apply at the appeal level. I mean, at the initial application level. I say that, and I also then caution it with, like, if there's somebody who's a repeat applier, like applies 10, 12, 15, 18 times, Social Security might go, ding, 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 red flag, and they might not process any more applications. But typically, if a person's applied and been denied, they can reapply. However, if a person is applied and then is denied, and you go all the way up to the ALJ hearing and have an ALJ hearing, and the ALJ hearing is still unfavorable, then a person is barred by what's known as res judicata. It's a legal term meaning like you're barred from having a new hearing or new application on the exact same issue, because you've already essentially gotten your one bite at the apple, and Social Security is not going to let you take 10 bites of the apple. So you're barred from reapplying if you've gone all the way through the ALJ hearing level, unless you can show Social Security that you have new symptoms that were not evaluated or decided in the past ALJ hearing, or there's a severe worsening in the symptoms that you reported and went to hearing on. In other words, they're saying you've gotten your due process, you got all the way to ALJ hearing, and you got denied. You can't just restart over again and ask us to do a whole new evaluation. Like, you got your chance. But if the person has new symptoms or severely worsening symptoms, then you could apply, and you would just have to explain to Social Security, yeah, I have an ALJ decision on this, but actually there's more to it that didn't exist when I had the ALJ hearing the first time and got denied. Okay, all right, I'll pause there and just say, yeah. So we covered quite a bit in this presentation about basic eligibility, the difference between the programs, how to apply, how to appeal, and then we just started to delve into issues related to post-eligibility, which we will be discussing again next week, because unfortunately, continuing disability reviews are not the only post-eligibility issue that comes up for our clients, and we want to make all of you aware of the other issues that people often struggle with. So we will be talking about that next Thursday. In the meantime, please know, Deepti, services are for Santa Clara County residents. Yes, correct. We only operate within Santa Clara County. Please know that you can refer clients to us, and there's quite a few ways to do so. You can fax a referral form to our fax number. You can email a referral form, or even just send us an email generally to healthintake@lawfoundation.org. You can go to our referral online system at tinyurl.com. You can have our client, or you can call our intake line. We do live calls Monday, Tuesday, Wednesday, and Thursday from 1 to 4 p.m. If you can't get through to us live, you leave a message, and our intake workers are calling people back in the mornings. You can also have a client come into our office for walk-in hours. Our office is at 4 North 2nd Street, Suite 1300, which is the 13th floor. That's in downtown San Jose, and the zip code is 95112. And we have walk-in hours on Tuesdays and Thursdays from 1 p.m. to 3 p.m. And then we also hold multiple clinics. So if you have clients who receive services at any of the following places, they can come see us at our clinic. So we're at Valley Specialty Center on Bascom Avenue in one of the main buildings there at VMC every Monday from 1 to 4. We're at the Reentry Clinic, which is right in downtown San Jose near the criminal courthouse and the jail. And we're there first and third Wednesdays of the month, 1 to 4. We're at the Hope Clinic on the first and fourth Thursday of every month from 1 to 4. And then we are at the Lexian Clinic over on, oh gosh, why am I forgetting the name of the street? I can't think of the name of the street. It'll come to me. And we're there every Friday from 9 to 12.
Alexian.
Yes, Alexian. Oh, it's Alexian Drive. Duh. Thank you, Charlotte. I was just laughing at myself because I'm like, it's at Alexian on Alexian Drive. And then it looks like Sadaka answered the question. Yeah, we're going to be providing slides so that you don't have to memorize all this. So just a question from Deepti, assuming that the client has worked with you directly, and case manager cannot speak to you on behalf of clients. If you're trying to talk to Social Security on behalf of a client, you need an AR, or if you want to get mail for the client, you need an AR. If you're just trying to speak to us because we've been helping a client and you want to know what's going on, the client just needs to sign a release of information from you guys. Like, let's say you have your own release of information and that release says, you know, this client can speak, you know, Deepti can speak to Law Foundation on behalf of this client, and the client signs it and you send it to us, we can share information with you about the client. Otherwise, we can't share any information because we're, as lawyers, subject to rules of confidentiality. So we can't share information without the client's express permission. Okay, another question. If a client already submitted an SSDI and did not submit an SSI application, can they still submit it later? Yeah, and I would say if somebody submitted SSDI, I'd go in as soon as possible. Like, actually, can you add on SSI to that, please? Just ask as soon as possible. But yeah, it can be submitted after the fact. Yeah. Okay, next slide. I think we might be at the end. Yeah, thank you. So I think this goes from 1 to 3. You know, if there are more questions, I'm happy to stay on a little longer and answer any other questions people have. Where can we obtain your referral form? Yes, 1 second. If you don't mind hanging on, I can pull it right now. 1 second. I'm just going on to our intranet site, intranet. I think it's in our OneNote folder. 1 second. Hold on, OneNote. I'm getting there. Take a second. Health intake. Here we go.
We also have the online referral form.
Awesome. Yeah, the URL.
Yeah, that we can through there.
Yeah, give me what I'll do is if I can send it to Sadaka, who can send it to you. I'm just poking around our OneNote system to try to find, and maybe I can look right here. Referral form. 1 second.
And yeah, after this presentation, I will email everyone who has registered for this training the slides from today, and then I can also email the form that Rachel is looking for. And then I'll also a feedback survey just so you can tell us how the training went for you.
Yeah, I'm poking around. So our intake specialist, Jasmine and Christine, have all of this information saved. Oh, here we go. I think I found it. Here we go. 1 second. I'll put a referral form. 1 second. Okay. This is a tiny URL one. This might be the easiest to use. 1 second. Here we go. I'm going to paste it in here. Can everybody try clicking on that, or can somebody try clicking on it and making sure it takes you to Law Foundation of the SD Health Program online referral form? And then here's the health, here's the other form. That looks like the same form.
Yes, it does. It does. I clicked on it.
Okay, great, thank you. Yeah, that's the best way. I'm gonna ask our intake workers where there's also like we have a paper form as well. I think we do, and I will have to get that and I will send it over to you. That for a fax referral. Fax referral form. Okay, I'm not finding anything else off the bat, but I will check in with our intake specialist and get back. Any other questions I can help answer at this time? Let me just go back to the presentation and see if those posted stuff. Okay, yeah, okay. Anything else, let us know. I can hang for a few more minutes. Okay. Well, if nothing else, we thank you so much for your time and participation in today's training. And we look forward to hosting you again next week when we talk about additional post eligibility issues.
Thank you, Charla and Rachel, for presenting today. Look forward to seeing you all again next week.
Thank you.